Hi there, my name is Vicki Giambra, and I'm an immigration attorney at Victoria Slater Giambra PLLC. I just wanted to provide everyone with a quick update on President Obama's immigration executive actions. One of my favorite things to do as an immigration attorney is work on unlawful presence waivers, also known as I-601 waivers. These waivers allow immigrants who are in the country unlawfully, maybe they crossed a border without being inspected by a border officer, or they overstayed their original visa, but it allows them, an unlawful presence waiver allows them to fix their status. They do have to prove extreme hardship to U.S. citizen or legal permanent resident, spouse, or parent. Back when I started doing unlawful presence waivers in 2009, my clients had to submit their waiver packets to a U.S. embassy or consulate abroad, whether in their home country or another country, which often meant leaving the United States to get it adjudicated and waiting for 6 months or a year for it to be reviewed and a decision to be made. In 2013, under President Obama's executive actions on immigration, and in the interest of family unity, the Provisional Waiver Program was developed. This allowed certain categories of people to apply for an unlawful presence waiver while still in the United States. This meant that they did not have to leave the U.S. without knowing if their waiver would be approved and risk triggering a 3 or 10-year bar to re-entering the country. Today, USCIS announced a rule, which goes into effect August 29th, that expands eligibility for provisional waiver process to all people who are statutorily eligible for the waiver of unlawful presence ground of inadmissibility. This means that all immigrants who are in the U.S. unlawfully and are eligible to receive a green card, whether through a family-based immigration process or an employment-based immigration process, can now apply for an unlawful presence waiver without leaving the U.S. The person still has to prove extreme hardship to a U.S. citizen or legal permanent resident, spouse, or parent, but they don't have to worry about triggering a 3 or 10-year bar without knowing if the waiver will be approved. I'll be doing a more in-depth analysis of the final rule published by USCIS soon, but I wanted to give you the good news now. Thanks.